Hi, ladies and gentlemen. We are back with the API Business Talks. Today we have a special guest, Max Feucker. I will talk with him about IP process management. But before we start, I have some housekeeping information for you. For the ones who are regularly in our show, they know that this is live. And why is it live? Because you can write comments under these posts, and I will see that here in the studio. And when it's anyhow possible, I will ask our guest, and I will pick up your comments so that we can really discuss together these topics. So, as I said, today with us, Max. Max is a European patent attorney, and he's really a specialist in IP process management. And maybe it sounds like something which is very common or well known. I learned from Max that this is really a tricky issue and a cornerstone and a key piece when it comes to value creation. And that is why we choose that title for today. But first of all, Max, thank you very much for being with us today. So can you tell me how did you came into this, let's say, a bit strange field of IP?
Thank you, Alex, for having me here today. Well, my name is Max Feucker. I'm 45 years old and I'm married to Diana, and we have two sons, Paul and Ole, who are 15 and 13 years old. I'm an enthusiastic cyclist. So now I start with my IP-related career. So it all started in 2009 after a physics diploma in Berlin and 1 year of scientific research at the University of Schleswig-Holstein in the field of heart surgery. At the end of my physics studies, I had an internship at a small Berlin patent law firm, and I was always playing with the thought of becoming a patent lawyer. And after my 1 year in Kiel in Schleswig-Holstein, I was eager to start my training, and the training started in Düsseldorf in a mid-sized patent law firm. And after I graduated, after I became a patent attorney, I joined a boutique patent law firm in Ratingen by Becker and Miller, and I shortly after became partner in 2013. Well, that is, so to say, my introduction into the IP business. And of course, as a young patent attorney, I was like really digging myself into the cases, and I was eager to solve each case as best as possible. But with the time, there came a more interest in the broader scope, and it actually started with the digitalization of our firm here in Ratingen. So during that digitalization, I really streamlined all our internal processes. By this streamlining, I really experienced firsthand how important it is to have clear processes and responsibilities in order to achieve the best results in an efficient manner. On the other hand, I also experience how high the pain can get if you want to change long-standing processes. During that time, I also started to introduce digital tools to collaborate with my clients. So there were the first steps that we did not only write emails with each other. So this way I come to my clients. I'm mostly working for small and mid-sized companies in which usually only one employee is responsible for the IP, but not in full time. It is usually an engineer in the development department. So during all of this, development of myself, I wanted to get even more close to my clients, and I founded a new patent law firm this year under the name of Patentstrategen, which actually focuses on the support of those mid-sized companies without an internal full-time IP expert.
So when you say mid-size, what does that mean? I mean, mid-size can mean a lot. And in Germany, we have SMEs. So Bosch itself calls them a Mittelstand, and it's one of the biggest companies in Europe. So what is mid-size?
Well, for me, I really tried to define it with regard to some revenue or number of employees. But actually, I think for me, in this definition, mid-sized is a company who regularly files patent applications, and let's say about 2 to 5 per year. So it is the number of patent applications which can be handled internally by a person who is not that experienced or who is not a patent attorney, and where you need support from the outside. So for me, in my definition, where I say I support mid-sized companies, are those companies which are familiar to IP, but which are organized internally and which need external support.
Okay, got you. So today we want to talk about your special knowledge about processes. And for the ones out there, Max has already a IP management letter about IP work, and he was with me. This content was with me at the Nordic IP Day, and here you get the slides and also an explanation what Max's approach makes different. In addition, he has his own page on the digital IP lexicon. And one thing we want to talk about today is especially his white paper, a checklist here, enhancing IP risk management and value extraction. So that is what we want to talk about today, and this is for you free to download, and hopefully that is something which can help and also initiate discussion on that topic. So now my first question to you, when I think about process management and also these more administrative things, on the other hand, the strategic thinking around IP. So in many companies, my experience is that in many companies, IP, especially patents, are pretty much something which is used in a defensive way. So I want to be, that is this term, I want to be protected. Protected against what and whom? And my question is more when we talk about processes, for example, filing and filing strategies. So what is your approach and your experience about to align that with, so to speak, real business goals, right? So we would like to see a certain, let's say, commercial impact and economic impact. And how can we align that when, the typical approach is, there is an invention and should we file it? Or even worse, can we file a patent for this invention? Then the impact discussion, the economic impact discussion is far away. This is a more legal question. So what would you say? How can this alignment be created?
So an optimized filing strategy is linked with the company's central business strategy. Thereby, it involves that a systematic approach to identifying innovations is inherent. You need to identify which aspects are worth of protection, and in the first case, so you need to know what can I protect. On the other hand, you need some kind of prioritization. So let's say, which invention is worth to be protected, because you can spend a lot of money for filing patent application, and you only patent the next screw on the left-hand side, So sometimes it might be worth it, but you need to have some kind of prioritization in order to define your patent strategy. So, and then you need to identify what kind of IP is useful to protect the new invention or the new innovation. Is it a patent, a trademark, a design, or is it even better to keep it as a trade secret? So from my view, it also starts a little bit earlier. You need to have some kind of awareness within your company for IP matter. So not only the one who is responsible for the IP should be aware that patents can be filed and trademarks can be protected, but also people in the development department and the sales department, or even in the marketing department, should be aware that IP is a crucial asset of the whole company. And if you have a decent strategic alignment of your filing strategy with your business goals, you really reduce the investment risks, because you don't spend money on patents which will not be protecting your product as you want to protect this. So perhaps if you want, I would like to give a specific example on how with one client we try to implement such a strategy, but on a efficient way, to say it. So it was clear there's a new product, a really new product. It's a new concept. I mean, it's still the same product as before, but a different concept of the product. Yeah, it's the same market. The client knows the market, but it's a really new concept of the product. So we did a first rough FTO, and we didn't identify any prior art or any patents. So we filed this first patent application, which was directed to the new concept. So that would be the classical approach, to have some kind of defensive protective right. But then we said, well, we will await the first search report and see if we get the protection with the first application as we expected it, so that we can really protect the whole concept. So when we received this positive search report, we identified further solutions which might provide the same value to my client's customers.
That came from the search report?
No. We had set up this. We have regular calls or meetings, and there is this meeting when we say, well, if we are like 4 months before the priority date, we come together, we evaluate all the crucial information regarding the development stage of the product, regarding patentability of the first application. And then we discussed if we can somehow draft further applications which protect different products, but which these different products, they have the same value for the customer of the client. Yeah, so they have
the value proposition.
The same proposition. So, and let's say it like this: it seems that these further applications are really more bothering the competitors than the first application. Yeah. So
okay.
It's really, I think, a really good case how you can actively try to think of additional patent applications in an efficient manner. So you don't need to.
Excuse me, but just out of curiosity, so you have not a problem with the provision that it has to be new when you say you have a further. So this further development was again new and inventive.
Yes, right. Well, it wasn't really a development because it was just on paper. It was just it was just a brainstorming and thinking how could we work around our own patent, and which had a similar effect, yeah, but with a different solution.
Okay, so, wow. So that means you start with a, so to speak, real product, and after that you become more abstract and you say, okay, this is what we're doing, and here comes more the protecting approach. But then you say, okay, but we could do it, or somebody could do it in a different way and could have not the legacy of our machinery, of our manufacturing capacity, of whatever, our technology. So when you have a different approach and just want to provide a similar customer benefit in this situation or in this use case, you could do that in a completely different way, and you patent that just to, so to speak, block the competition of offering such a solution, such a product, to have an exclusivity in your market for your product and your value proposition. Is that the logic?
Well, that is very well recollected. That is how the logic behind it. So wow. we didn't do like this brainstorming or thinking about different solutions at the beginning, because on the one hand we saved the money for additional patent application. On the other hand, it wasn't really sure if the first product really works as it could be wished. And I have to say, the product wasn't published yet. It was shown to some customers, and they were really excited about the new product. So it wasn't state of the art yet when we filed the further applications.
Okay. So, but that means that means that you have to convince the company to file, let's say, something. Okay, you file something which is new and inventive, and the company don't want to produce that. So you file it because you don't want to see it in the market. And I think that is for some, let's say, I mean, of course, we see that on a day-to-day practice on the multinationals. We see that as a best practice for lots of IP-heavy companies, like Apple, for example. They have 1,400 patents for Shazam, and only a few of them are implemented in Shazam. But all the other patents are simply for blocking competitors or certain competition simply not to go into that market of music recognition. That's it. I mean, that's a very well-established thinking. But to convince an SME to invest in a patent for something which they do not produce, they even have not the intention to produce it, but to block competitors, that sounds to me like a hard job. So how did you convince them to do so?
Well, I do try to convince my clients more regular, but I have the finding that if the patent is directed to some kind of development, as you called it, of an existing product, it is harder to convince the client to file additional protection. But in this specific case, it was just a new concept of a product, and it seemed that it is really worth it. That is the decision. If in other cases the client probably, or he just calculates, what are the costs for an additional application and what is the benefit which I can gain with that specific product. So, and then if you multiple the cost for IP protection by 3, it sometimes doesn't really work out anymore.
Yeah, yeah, got you, got you. Okay, yeah, that sounds extremely fascinating, to be honest, because I think that that convincing part is really an issue here, and I mean, because simply having that workshop, okay, so there was a workshop. You said you a discussion with their very expensive R&D guys to think about alternatives for the product. Yeah, I mean that's a big thing. You use a very scarce resource from the company to think about something which they don't want to produce, and you say protecting. I don't think it's protection. It's blocking, and it's a different function of IP, which is extremely effective, obviously. But yeah, again, it's a question of investment, and that the company said, okay, we are willing to do so. I think that's really a showcase how it should be done.
Yeah. Right. But I think it's my responsibility to bring up those ideas that you can do something like that. And I also bring forward arguments. And let's say, I think you don't need to do it, or not in every case, but in this specific case, it was just so clear that blocking the competitors from similar solutions is just a really big advantage, which can be justified in higher returns. So
Okay.
it's always an economical decision. Yeah.
Of course, of course. I mean, that was the starting point. We want to support economic impact, and that's the reason how to go for it. And I mean that when you start with that, yeah. So it's not about protecting inventions. It is about optimizing returns of innovation. And when you have this perspective, then you come to completely different solutions. As you said, then you invest money in creating solutions which you even don't want to produce. You want to block for good reasons. Okay, so let's come to the risk side of the whole game. Yeah. So what I hear often is, yeah, yes, we make an FTO once we go to the market. And so obviously you accumulate all the risk that you will have a problem when you want to go to the market when you do your FTO too early, too late. Also, what means late? Downstream in the innovation process. Yeah, so now the product is ready. We have already ordered the machines. Everything is done, and then somebody throws the project over the fence to the IP guys and say, "Okay, honeys, just check whether we are allowed to do so." Okay, and then the IP guy comes back and say, "Okay, I have bad news for you," and then IP is bad. Yeah, so IP just creates problems. So you recommend to do it early in the innovation phase, but then I hear, yes, but how can you do an FTO when we don't know exactly what we want to do? So it's an early innovation phase upstream in the innovation process, and here we have a lot of opportunities how we could solve it. How can you make an FTO for such a situation? What is your approach on that?
Well, it's like a stepwise approach. So as you said in the beginning, you don't know really how exactly the product will look like. But there is a first idea of how the product will be constructed. So actually, we do a very first more or less draft search, which is more, it's not that complete. It is not directed to every specific feature, but it is directed to those features which have been altered by the development. So we try to focus the FTO search to those aspects which have been altered in contrast to the previously product. So we don't start by saying, well, please do a search for everything you see in this construction, but we really specify some particular features to which the search shall be directed.
Okay.
So, and then it is also a short communication between me and my clients. It's not like I analyze all patents and then I write an opinion about 30 pages and I will send it to the client. It's a little bit a stepwise approach. I do a first screening of the identified patent rights. So, and usually with such a first screening, I can really already identify those patents which might be relevant and which might be crucial. And we had this case with this one client. We identified exactly one relevant patent, and I explained the scope of the patent to my responsible person in the company, and then we discussed this patent with the persons of the development department, and so there was an understanding what is protected by the patent. And then in a mutual effort, there was found a solution which works around the patent. So it was really a quick approach. It didn't take more than 2 weeks from identifying the patent to having a workaround solution on Scratch. It was really early because they didn't have ordered any tools or so yet. So we had a workaround solution within 2 weeks, and this workaround solution was then the basis of my complete opinion. But the complete opinion wasn't ready while they were working. They received the relevant information from my side as early as possible, and then we came into a discussion, and the product was actually altered, and it saved the cost for one tool. They would have produced one tool to produce a first product for testing, and it was avoided that this first tool had to be destroyed and that another tool need to be.
Okay, got you. So what you say is, so what I understand is that an FTO is pretty much an interactive approach, an interplay between the IP knowledge on the one side, expertise, and on the other side, the management, the innovation management, the R&D management in the company to find out how to come up with solutions and not just with problems. And the earlier you are, the more flexibility you have to also bypass existing solutions or existing patents, and to ease the situation in terms of potential infringements. So there is a wonderful question which I would like to pick up here from Bart, and he said to our earlier topic. Okay, so he said, would the competitor take your patent seriously if the brainstormed ideas are not enabled? And I think that's an interesting question. What is your position on that?
So just to get the question right, the question is if those second filings, which we drafted on Scratch, would be taken serious. Yes, I actually, this is some kind of the problem I was referring to. I think the competitors didn't take it serious. They probably just analyzed the first patent, which was to the new concept of the product, while now it might be that they fall into the scope of the second filings. So it's really some kind of a build-up case, yeah.
Sorry, I don't get the point. So, in my opinion, it is absolutely irrelevant whether you produce something or not, as long as you have a patent and you are willing to enforce it. It's very simple. Also, why should a competitor or any third party don't take a patent serious as long as I pay my fees and I have the money in the pocket and the will to enforce them?
That's what we will do now.
Okay, thank you. I didn't get it completely. Yeah, okay, that's exactly the point. I mean, to a certain extent, I don't understand the question. Okay, I mean,
no. So that was why I wanted to clarify the question. So I think the competitor should take every patent serious. It is enforced, and the implications are always the same. So
exactly, and basically, it is not a question of whether I'm producing it or not. It's a question which reputation do I have in the market to take patents serious. That's a different thing.
And we will build up this reputation now.
Exactly. I mean that is much more important, and that's also from time to time a recommendation. When you don't litigate from time to time, when you don't negotiate from time to time, and let your competitors know that that you don't file IP for fun. So then you have to create a certain credibility on that. That's also my recommendation when we talk about case studies and companies. Oh, we are not sure whether we would like to talk about our IP. I said, okay, come on. The most important thing, what you should let your competitors know, is that you are absolutely serious on IP and that you manage it in the best possible way, and let the people know that. And then you have maybe some trouble not compared to the situation that people think, yeah, you play the game a little bit, but not really. Okay. Let's come to the competition. So typically, this is a game that all parties. So it's a multi-party game, and all of them have their IP. Let's say patents, and then you would like to find a way to bypass or to position yourself. So that's called white spot analysis. So how can these monitoring of competitors and this white spot analysis help to to identify also opportunities? So is that a way to find interesting, lucrative, profitable spots in the market or in the technology? What is your experience with that?
Well, besides that, it's sometimes technically difficult to identify those spots. I think it's one of the basic measures you should take. You should have a third-party observation running, and you should identify those rights which are or might be relevant for the future, and you should somehow classify them in your own way, so
Okay.
that you have your own database at each time when you develop something new. So just to give you an example, we talked about the FTO before.
Yes.
If you have a really good database, and which might also be accessible from the developers themselves, you can really do a rough first search on your own if only those patent application IP rights are in the database which were identified as possibly relevant during the monitoring. So I actually have one of my clients. He has a database which he's using for more than 10 years now, and it's a treasure. Yeah, it's a treasure. You can not only regarding FTOs or during the development process, but also regarding prior art if you want to attack the patent of a third party. So
and this is focused on a certain technology from your client.
Yes, right. That is. So he has basically probably all active patents in his database of the relevant players for the last 10 years, and as you all probably know, if you start a search from scratch, you have to you first have to identify all those of potentially relevant one, and so that I think to really have a process going for the third-party monitoring, that might be sometimes a little bit tricky in the beginning to get everybody used to it and to teach the people how to read patterns and how to classify them. But if you do it on the long term, it's a treasure.
Okay, got you. So when you say treasure, that means you identify business opportunities, or you identify not existing technological solutions. So what is the treasure here? I mean, yes, it's a huge amount of data. Thank you very much. I mean, where comes the value in it?
I think the value comes in it if it is accessible for not only one person in the company, but for multiple persons. Because otherwise, you have this huge amount of work each time you want to make a search.
Okay.
Yeah.
Well,
so I think
the reduction of search time. Okay, got you. Okay, so you have relevant information here. So yeah, but so how do you convince? I mean, I have often heard that reading patterns is for some people really a pain. Yeah. So I mean, it's not that kind of literature people like to read, and you have people with a closer affinity, like R&D people. But your point was that you would like to have really other, so marketing people, product managers, to really read original patent literature. Is that your approach?
No. I think it is too difficult to read them really in detail, and it is.
No, maybe just to understand. To everybody could read it, but nobody understands it.
Yeah, but well, I don't think that salespeople need really to understand and to classify patent application. But if the developers do it, and if they classify them correctly, also the salesperson might know that there is a patent, and then they can start the discussion. Yeah. So and on the other hand, it's also about number of relevant patent applications which you need to screen every month. Yeah. So you want to keep them at a number which is possible to screen within an hour or two. You can't, if somebody has to screen them for a week, or for 1 day a week, you probably won't have time for it.
Yeah, absolutely, especially not in a mid-sized company, right?
Yeah.
So compared to the amount of money, which again, I mean, we have very limited R&D resources, and that are the smartest technical people in the company, and they are blocked with reading patents. That's maybe not what you would really like to have. So Udo Gennari has an interesting question, which I would like to pick up. So when it comes to these FTO search, who is doing that very practically? So is it you, or is it the representative of the company? And also for making that information available, so we have out there a process management software. So how is that done in companies which you mentioned, around 5 patent applications a year? What is your experience here? How can that be done? Maybe based on a software tool, or is that not necessary because it's not enough? It's not enough content which is used here. What is your recommendation? Or first, what is your experience?
So my approach is that I work out a search strategy together with a client, in which we specify the aspects which should be searched for, and in which we define IPC classes, competitors, or other words in combination in order to specify the search itself. And then the first classification of the hits, this is outsourced. Yeah, we outsource this to a search company, and they deliver to us those which they find relevant, and I analyze those which are found relevant by the search company myself.
Got you. Okay, so it's a joint approach, and it's also, I would say, I would assume, cost efficient. That different service providers do different parts of the job.
Yeah, so the risk remains that the search company is not that familiar, and there might be some protective right overlooked. Well, but there's you always have some kind of risk, and this way the development department is not involved in doing the search and does not need to spend 2 or 3 days for the search.
Yeah, whatever.
And for me, if I do it myself, well,
no, I mean it's the decision of the least bad solution, right? So it's simply the company can't do it, especially they don't know how to do it, and when they spend the time, it's even more expensive. So that when you do it, it's also not really effective. So we need somebody to do it at a reasonable cost base. I mean, basically, this is something which I really hate in these IP discussions always. That these discussions are in a kind of vacuum, an economic vacuum. So so what should we do ideally? So yes, so this is not a problem. Yeah, read the textbook and you know what you should do ideally. The problem is that we have to live in reality, and in the reality we have cost issues, and we have to play business administration, and that means we have limited resources, and that means we have to find the best solution for limited resources. And I think that what you explain us here is absolutely reasonable to do so. I mean, for me that makes totally sense. So unfortunately we run a bit out of time, but I have a final question to you. Maybe you can give us a short answer. It's about so what I hear again and again is that we have this IP and it is so to speak not core. So then you could ask the question why you have that anyhow, but it can be that the company decided to go in a new direction, new technology, whatever, and we have that IP now. So what is your recommendation how to treat that kind of, let's call it non-core IP assets? What is your approach with that?
Well, I think this non-core IP exists if you, over the long term, have a more active approach, and you keep those patents which you do not use yourself. So in this case, I think that is the time where you can combine your database. You can see which patents of your own you do not use, and if they are in a technical field which is, for example, used by a competitor, which you might know from your third-party competitor observation, and then you can try to license those patents.
Okay, or even to sell, right?
Well, yes.
Yeah. So that means what I understand is what you say is it is always good to be good informed, right? So it is good. I mean, that's the point, isn't it? I mean, yes. So many, the alternative to all of that, what you told us the last 45 minutes, is simply ignore it. And unfortunately, I hear that pretty often, that this whole thing is not relevant for us. Yeah. And what you say is, when you have this information in place, it is a treasure, because you can avoid these risks, these costly risks, about litigation. You can create a blockage, which means you have de facto exclusivity with price premium opportunities. And you have even the opportunity to license or to sell IP which you have created, where your ingenuity lies in, but for whatever reason you can't make use out of it. And all that comes with a better understanding of these IP processes and with a proactive approach to do it. So that what resonates to me pretty much what you say. So thank you very much, Max. We have some announcement for all of you who want to become a subject matter expert at the IPBA Connect, and we are happy to work with you in the IP Business Academy. Check out, we will have also this information in the discussion later on. Max, please stay with us on LinkedIn for the next hour. So I was not able to pick up every question from the chat, so please answer to the questions. So Max will be available over the next time to discuss with you on LinkedIn in the chat. Thank you very much. Thank you, Max, for taking the time to be with us.
Thank you.
Thank you. Bye-bye. Take care.
Bye.